Hi, good afternoon, everyone. Thank you so much for joining us today. And we have Evan Drachman, who is a real estate attorney and property tax appeal attorney. And he's going to go through the different steps, what you need to know, and how to get a successful tax appeal. And also we'll have a Q&A as well. Evan, take it away.
Hi, everyone. Tax appeals is the topic today. Always a popular topic, simply because everyone loves to save a little bit of money. So how do we do that? First, in order to get to really the process here, it's important to really understand how taxes work and how taxes are assessed on a property. Taxes are determined with two basic factors. There's a tax rate and the property assessment. The tax rate is determined annually by each individual town, and the tax rate is based on the budgetary needs of that town. So it's simply a matter of the town knows how much the property in town is worth. They use the tax rate to make sure that they raise the amount of money. The assessed value, keep in mind, when you're dealing with the tax rate, there is no appeal on that number. That number is the same across the town. The only way to really change it is to speak to your town council, your mayor, your local government. The other aspect of taxes is a property assessment. And that is a number that is assigned to each individual property in any town. That number is intended to be what that property is worth. The reason why I say it's intended to be is because the number, the assessed value of a property, does not change on an annual basis. Market values, of course, change all the time. But in order for a town to really change their change their assessments, they go through a process called a revaluation. A revaluation is an expensive process. It's a time-consuming process, and it doesn't happen every year. It happens every 3 to 5, sometimes 7 or 10 years. So there's really no way to know for sure when it's going to happen, but usually you get a year or two in advance. For example, right now, Livingston is going through a revaluation. So every property in Livingston is having a new value associated with it. Now, in towns that are not going through a revaluation, you have an assessed value that was the property value at some point in the years past. Sorry, technical problem there. So at some point in the year past. That value may have changed and may no longer be the actual market value associated with your property today. The way that we use that assessed value and determine a market value is a ratio. It's called a chapter 1-2-3 ratio, and I'll repeat that in a moment. But what that ratio does is that it's a ratio of assessed value to market value. And it is issued every year by the town, and it's intended to update the assessed values of that town and update them into what current market values are. So you take an assessed value, you divide it by, you take the assessed value, you divide it by their market value, and you have a ratio. And that is the ratio that the town tries to hit on every single tax appeal. When you're trying to figure out what your ratio is, you really just have to Google chapter 1-2-3, and it's called chapter 1-2-3 because that's the state law where that's the state law that dictates the state to issue these ratios. And then you get a little chart for every county that looks kind of like this. And if you can see it, there's a category for upper limit and lower limit, and as well as average ratio. It's the average ratio that really is the number that converts your assessed value into a market value. Now, why is all of that important? The reason it's important is because when you're looking at your taxes, you're going to think your taxes are too high. Everybody does. However, when you're going to figure out why your taxes are too high, you're going to look at your assessed value. And that assessed value you're going to look at, and it's just not an apples to apples comparison of your market value. So it is important to understand, maybe not every single detail, but it's important to understand the relationship, how that assessed value relates to the market value. And it's by using this ratio that's issued by the state that converts those two. Now, how do you know that if you're going to have a successful tax appeal? Again, we go back to the ratio. The government is the party that you are appealing your taxes against. The government issues a assessed value on a property. They issue a ratio on the property. And when you appeal, you're telling the court that you think the government made a wrong determination. So you appeal your assessed value. You cannot appeal the tax rate. You cannot appeal the ratio. You appeal your specific assessed value. And after you've converted your assessed value into market value, that's what you're really appealing. You're saying that the town has assessed your property into an assessed value, which converts to a market value, which is just simply too high. However, it cannot be too high to win. It has to be at least 15% too high. Now that seems arbitrary, but it's what's called the corridor. And the corridor means that if you are overassessed by 5%, 10%, the town just doesn't want to hear about it. They don't want to have everybody in the town who can save $200, $150 on their taxes appealing every single year. So they created this corridor. And the corridor is a 15% corridor. So when we're going back to the ratio, that's what these, and I apologize for peeking over, that's what these numbers indicate. The average is the ratio, is the number that is used to convert an assessed value into a market value. But the upper limit and the lower limit, those represent the corridor. Those represent the 15% above and the 15% below. Now, with all of that being said, there's an easy way to determine what your assessed value is, whether or not a tax appeal is good, and it brings together all these different parts. You have to look, first you look up your assessed value. You should have an idea on what your market value is. Market value is just, if you were going to sell your home today, what would you get for it? So it's simply a question of value of your home. When you take your assessed value and you divide it by your market value, you come up with a ratio. That ratio, it's a number. It's gonna be 0.0 something, 1.0 something, 0.7, whatever it might be. If that number is higher than the upper limit, again, going to the upper limit here on the chapter 1, 2, 3 ratio, it's a successful tax appeal. It should be a successful tax appeal. It means that the numbers are there, that you are overtaxed, and you should be asking the municipality for relief on your assessed value. Now, how do we ask for relief? You can't just say, well, this is what I think it's worth. You have to actually show comparable properties and evidence of what your property is worth. Now, when you're appealing, we're living through, specifically right now, we are living through uncharted waters and a very unusual time. And a lot of people are very concerned that property values are dropping. Unfortunately, that doesn't really help for a tax appeal, because what we're proving in a tax appeal is the value of on October 1 of last year. So you might think, okay, my property in today's market, I don't know if I could get the same thing I could get 2 or 3 or 4 weeks ago. While that might be true, that's not what a tax appeal is asking. A tax appeal is asking, what was the property worth October 1 of the last year? Now, just for context, October 1 is the date on which tax assessors have to actually certify what a property is worth. So that's why a tax assessor is not intended to know the future. So the question is, what was the tax assessor working with? What evidence did the tax assessor have on that date to come up with that value? When you're filing an appeal, you appeal going backwards, October 1, and you use evidence that of any property that closed on or before October 1. Now, occasionally there might be a very good comparable property that closes after October 1, and the court may accept that, but it's weighted differently than the evidence of, let's say, September 30th of last year. So again, we're going back to October 1, and what was the market value on that date? If you take the assessed value and you divide it by the market value, and you have a ratio that is above what the upper limit is for your town, you should be able to win a tax appeal. And it really sounds overly complicated, but it's simply a matter of all these different concepts coming together into a formulaic enterprise to determine whether or not a tax appeal really can be successful. I hope that wasn't overly confusing. It does take a little bit to get used to the lingo and the different parts. I'm happy to answer any questions or anything else that anyone needs.
So Evan, I have a question for you. So for example, let's say someone who have assessment of, let's say, $2.3 million, right? That's the town assessment. And then they actually purchased it at 1.7, something like that, right? So
Yep.
there's more than 15% of the difference for a tax appeal. Again, based on you look at October 1st, right? But at the same time, the town is not necessarily going to give you all that reduction all at one time. It will be multiple years, right? Most of the time.
Well, no. So the town should be giving you all of the reduction in the year that you win. So it can happen all in the same year. The reason why sometimes settlements will be over more than 1 year is because the town might not agree that what the value was. The town might see a declining market, know that you can, we could settle on one number this year and appeal could be following the next year. So whenever there's a settlement, whenever you make an appeal, you only appeal a specific year. So the only time that there is going to be future years as part of a tax appeal resolution is when there is some negotiated settlement. And when there's a negotiated settlement, it's really simply a matter of the parties, both the township and the taxpayer, determining that there's it's an easier path. Sometimes it's safer to say, okay, I'll take a 15% reduction and a 10% reduction the following year instead of maybe 20% in the current year. Because that might give them a larger reduction over time in the future years than they would be able to secure this year. So whenever there's future years resolved, that was because there's a tax appeal settlement, and that was how the parties were able to come to a resolution. Now, keep in mind, you mentioned one thing that I just want to try and clarify a little bit, and that is that there's a 15% threshold between the assessed value and the market value. That is not 100% accurate. The 15% has to be there has to be more than a 15% difference between the market value of the property today and the converted market value of the assessed value. So when you take the assessed value and you multiply it by the average ratio, you have the number that the town really does think the property is worth. And that is what the town is taxing it as. And then when there's a 15% difference between that number and the market value, then you can have a tax appeal. The reason why that's valuable, and a good example is not necessarily Essex County. And the reason I say that is because when you look at Essex County, if this is visible, which probably it's not, but Essex County average ratios are oftentimes between 85 and 100. What that means is that the assessed values are not wildly off of market values. When we look at other municipalities, other counties in particular, for example, Union County, we have average ratios in the 30s and 50s and 20s. That means that if you're looking at an assessed value of, let's say you're looking at a property in Summit, and you have an assessed value of $100,000. That's only 42% of the market value. So in Summit, for example, if someone is looking at their assessed value, it's going to be wildly different than what their actual market value is. So that's where those ratios really do allow you to make sense of an assessed value that is decades old in all likelihood.
And when they go through the appeal process through attorney, they still need to prove similar properties. That's the reason you can get tax appeals. Is this still 5 properties, or has that changed?
No, so there is no requirement as to number of properties. The fact is that when you are filing a tax appeal, the burden of proof is on you as the taxpayer. So a taxpayer has the obligation, and of course a taxpayer will usually hire an attorney or a professional to handle this. The burden is on them to show what the proper market value would be. 5 is better than 3. It's better than 1. However, if there's a property that is incredibly unique, it's harder to get comps, and you have to cast a wider net sometimes. If you live in a townhouse community, for example, you're only going to really pull valid, good comps from your townhouse community. And there's going to be some that are almost exactly your home, whether it's your same model, say, all of those same factors. However, if you live in a much older community with a much older housing stock, houses aren't as set the same block by block. So the number of comparable properties is simply an evidentiary question. It's proving your case as best as you can using the most possible good, solid comps. It's not, generally speaking, it's a strategic decision as to exactly how many. 10 is probably too many because it confuses the issues. 1 or 2 is probably not enough because it's not really determinative. So 3 to 5 is generally the accepted number, but there's no requirement as to the number, high or low.
And since since New Jersey have extended to at least to May 1st right now, with everything going on, and how do you file tax appeal? Because normally they need to be in person, that you have to notarize and all dated and stuff. And how does that process work? And how long does a tax appeal take in today's day?
So the first question is a little bit easier. The deadline is, in any given year, the deadline is usually April 1st. That has been extended because of our extenuating circumstances. It has been extended at least through May 1st, like you said. But what I'm hearing is that their intention is to extend it 30 days beyond the end of the non-essential business order. So we'll see what happens. But for now, there is until May 1st to have tax appeals filed. Now, the way to file it is they're not opening the offices to the public. So you cannot go in and file today. You have to mail it in. There are requirements. When you mail it in, you have to fill out a specific form, send it into the county with a filing fee, and it's also required to be served on the municipality, both the town clerk and the tax assessor. So there are things that if you don't properly file and you don't properly serve all the appropriate parties, your tax appeal gets dismissed without even discussing what the merits of the case are. So it is very important to follow those steps. And even though there's a longer time period, those steps are firm and they have to be done. It doesn't have to be, none of this has to be done this year in person. So it all should be done by mail. But unlike, for example, income taxes, it's not a question of postmarking. It is almost always the county has always treated it as it has to be delivered by the deadline, not simply postmarked. Now, how does a tax appeal, how long does it take to resolve? Generally, it would be resolved May or June. This year, it's up in the air. We don't know, because if the tax appeal window, so generally speaking, the tax appeal deadline is April 1st, and sometime in the month of April and May, is when we start getting hearing dates, negotiating and resolving these matters and going to hearings. Sometimes those hearings extend into June. This year, we don't have, but none of the scheduling and the next step happens until the tax appeal window has stopped for filing after April 1st. That deadline is now being pushed back. There has been no indication that they're going to start scheduling matters because they don't know when they could even schedule them for right now. So we're at a time period right now where we don't know how long it could take to resolve the tax appeal because we don't know what the start date is going to be. Generally, you can presume that within about 60 to 90 days from the last day of filing, many tax appeals should be resolved. So if that last day turns out to be May 1st, like we're all hoping, June, July, August, by the end of August, most tax appeals should be resolved. Now, what's great about it, either way, is that when you file a tax appeal, the benefit of that tax appeal is retroactive to January 1, either way. So even if you file a tax appeal on the last day of April and the deadline is May 1st, and you win your tax appeal, you will get a tax credit going back to January 1 of the year 2020. And again, the reason for that, just to kind of bring it all back into context, is what you are appealing is the tax assessor's determination of what that property was worth as of October 1, 2019 for the tax year 2020. So if you're able to prove that you were overassessed, you have been overassessed for the entire year and you get the benefit of the reduction for the entire tax year 2020.
Evan?
Yes.
This is Tracy. A question about the proving what your property is worth. Say in Milburn Short Hills, which had their tax assessment done a couple of years ago, and someone purchases a house now at a price that is much less than the assessed value. Is that purchase enough evidence to bring as proof that it's not worth as much?
Usually, but not always.
Okay.
There are certain purchases that are what's called non-usable purchases. So whenever there's a distressed sale, that transaction cannot be used as evidence. Now, the most common distressed sales are estate sales, when it's an estate seller, a short sale, or a sale from a divorcing couple. Whenever that's happening, the township disregards that as evidence. It's not valid evidence. Now, if it is your transaction in particular, there are arguments you can make to bring that evidence back in, but it's not going to end up being determinative. You'd have to show some other comparable properties. It also matters the timing. If you have closed on if you bought a house and you closed September 30th, 2019, well, that's going to be the best evidence you can find, provided it was not a non-usable transaction. It was an arm's length transaction. It was exposed to the marketplace with real estate agents. There's certain really check marks that the town wants to see a property having gone through to confirm it is a good and valid comparable property. So if you've closed on September 30th, or really any time in the month of September, and you hit all those check marks, your evidence is going to be, while not quite determinative, extremely strong. If you closed February 5th, your evidence is going to be much weaker, because the question again is October 1, 2019. That's the important date. So evidence that has closed after that date is weighted differently. Now, what's interesting is that if it's closed, for example, October 15th, well, that's after the date. However, you can show usually that the contract was signed prior to the date, it was exposed to the marketplace prior to the date, and you can try and advocate for that being valid evidence using all these other factors.
This is Sam.
Thank you.
Can you hear me?
Yes.
Yeah. Okay. I have two questions. One is, I had my property in Livingston filed for appeal in 2018, and I got a little bit of a reduction. Can I still file it, or is there a time gap that you have to wait 10 years or 5 years, something? And the second question is, you said October 1st last year, what was the property value? But since now, then the property values have gone down, and I believe it will go down further. Should we wait till October 1st of 2020 to file it for the following year, or what?
So that's a very good question. And quite honestly, I've spoken with numerous clients this year where we're kind of on the bubble of that 15% window. Someone might be at 14%, and we could potentially prove outside the 15%, but we come to the conclusion that it's better to wait a year, in order to make that a slam dunk, so to speak. So the question of whether or not to wait to the next year is just strategic decision, but a decision that does sometimes make sense, especially if you're close. It's worth, excuse me, especially if you're close, it's worth waiting a year, because you can really maximize your reduction. If, for example, you're at 16% outside the corridor, and you file an appeal this year, but you can't quite get it to the market value, you bring it down maybe 8%, you're going to be barred from doing a tax appeal the following year because you're not outside the corridor, and it will be better to have waited to make a stronger case. Now, you mentioned you're in Livingston. In Livingston, the rules this year are a little bit different, and that's because of the revaluation year. And the rules for this year are specifically that you don't need the 15% corridor in a revaluation year gets disregarded. So even if you are overassessed this year by $1,000, you could successfully win a tax appeal. Now, if you're only overassessed by $1,000, the reduction you're going to get is probably going to be less than the filing fee, and it may not be worth it. But certainly it is a valid, in Livingston in particular, because of the revaluation, you can absolutely file this year based on any amount of overassessment. Now, like you mentioned, you said you had filed a few years ago. You can file every single year. There's no bar in doing that. Okay. So if you're not happy with the reduction you got, or you think things have gone down, you absolutely can file again. Now, with Livingston, again, because you're in a little bit of a different situation, you're now dealing with a new assessed value. You can appeal this year, and then if the market continues to decline, or if it does decline, we're at the very beginning, it's hard to even know yet. But if the market does decline between now and October 1st, 2020, you would have a valid tax appeal for 2021, provided at that point you're outside the corridor.
Okay, but like in my street, there's a house in front of mine. He has one extra bedroom, one extra bathroom, completely redone and put for sale completely. It's a new property, like an 18-year-old. Mine is also the same. But my valuation is more than that guy's, even though he has updated it completely. I told the assessor, I showed it to him that he's putting it for sale at a lesser price than what you're assessing mine, but they didn't listen. So can I use that property which was sold and updated and additional bedroom, everything as an evidence that I'm over assessed or overvalued?
Only if that property was sold and closed prior to October 1, 2019. Oh. You cannot use your neighbor's assessments as evidence, because you're not appealing purely the assessed value. You're appealing based on market value. Okay. So it has to be transactions that have closed in the relevant evidentiary period. So simply the fact that your neighbor has a nicer house and is assessed lower than yours, unfortunately, is not evidence. It's a very common question because everybody looks at their neighbor's taxes. So, you have to have actual closed transactions to be able to determine market value, and your neighbor's tax assessments just aren't used as evidence. It can't be.
So if I wait till October of 2020 to file an appeal, then I can use his closing as an evidence of the value?
Assuming he closes and sells the property and closes, yes.
He has sold the property. I just don't know the value, but
when did it close?
It is less than asking price because he waited almost 4 months to sell it.
When did it actually close? Did it close yet?
I think the board is off from last 2 months. So either it's taken off the market or it's closed. I don't know.
Right. Okay. So look, if it's closed, it becomes public record. So you can monitor and look for it, and you can certainly find the value. That's a public record issue. If it closed, absolutely, you could use that comparable. As long as you show it's comparable to your property, you can certainly use that as evidence and potentially secure a reduction.
Okay, so that will be for the next year. I can use his closing. You mean not current? Okay. Thank you.
Can you go into a little bit, talk about what's the application fee structure, and also what is the structure of the fee that you charge, and how does that work when you win the appeal?
So the filing fee. Look, let me reverse that. The way I handle tax appeals and fees is I charge a 50% contingency, and what that means is that I charge 50% of the tax savings in the first year. So for whatever year we're able to get the reduction, whatever year we're able to get a new reduction, I charge 50% of that reduction. Now for my fee, I then cover all other fee costs and expenses. So I cover the filing fee, I cover an appraisal fee if necessary. That's all on me. Basically, there's no, when a client hires me, there is no upfront payment whatsoever. I kind of handle everything. Now, the reason I'm able to do that is because I don't take files that I'm not confident I'm going to win. I make sure to vet all my files. I make sure to check everything, and I'm able to tell clients, hey, I think I can secure you an X amount of dollar reduction. And then we have a game plan, we have a goal, and we can usually get there. And because I know how much that reduction is going to be, I'm comfortable to cover all costs and expenses. If someone does want to handle it themselves or a different way, the fee structure is based on the assessed value. So I believe it's under $500,000 in assessed value. There's a $25 fee. Between $500,000 and $1 million, I think it's $100, and then over $1 million, it's a $150 fee. So that's the filing fee, and that just gets the application itself filed. Sometimes, depending on the situation, depending on the comparables available, there's need to have an appraiser to testify at a hearing. Usually an appraiser charges $400 to $600. That's usually what an appraiser will cost in order to prepare a report and attend the hearing. If someone is going to submit an appraisal report, there are requirements on how to submit it, when to submit it, and all of that is part of the process. It has to be submitted at least 10 days before the hearing, and the person has to be a licensed New Jersey appraiser if they're going to testify as an expert. Otherwise, if a homeowner is intending to testify on their own, they have to be well versed in the evidence that is being promulgated, meaning that they have to be aware of not simply, oh, this house closed at this, but what was the condition of the home? Where did you the questions the tax assessor's attorney are going to ask are, did you go into the home? Do you have familiarity with the home? All of these things where an appraiser kind of gets a pass because they're considered to be a New Jersey licensed expert.
So you mentioned
appraiser fee is in addition to your contingency fee?
When I represent a client, no, I cover everything for my contingency.
Okay.
So Evan, you mentioned appraiser a couple of times. So how very often an appraiser would help in doing the tax appeal?
The answer is how often? The answer is I don't know. Sometimes. It really depends on the factual circumstances of each case that I handle. Depending on when the buyer bought or sold, depending on what comparable properties we're able to determine, and quite honestly, in my situation, depending on my relationship with the tax assessor and whether or not we're able to get a settlement, that's really when we need an appraiser. What I generally use an appraiser for is testimony at a hearing. If we get that far, I'm usually able to resolve tax appeals that I handle by a settlement prior to any hearing. But if we have to go to a hearing, an appraiser is helpful because they act as an expert witness. So just like any other litigation, any other trial, you want to have witnesses that support your case. And licensed appraisers are considered automatically to be experts by the court. So having a licensed appraiser able to testify on your behalf is a positive when you get that far. But like I said, because I do the vetting ahead of time, because I'm able to, pull the comps, I'm usually able to resolve tax appeals before a hearing. The benefit being it takes away the uncertainty. When you go to a hearing, it's an all or nothing proposition. And when you're in a settlement, you're able to, most of the tax assessors know me, we're able to negotiate something that is fair and reasonable for the clients.
Someone just posted a question. I just closed on a house in November 2019. Can we use that finalized appraisal from our home insurance for the tax appeal?
So generally not. And the reason why, while the evidence and while the information contained in that appraisal might be useful, the appraisal report cannot be submitted as evidence because the appraiser who did that is going to be for your insurance company or your mortgage company. They are not going to be willing or generally able to testify. Those appraisal reports are generally done for the benefit of the lender, not for the benefit of you as the homeowner. So you won't be able to get an appraiser who's going to be able to attend a hearing and testify. And if the appraiser is not going to attend and testify, the report gets dismissed because the town doesn't have a chance to, in essence, cross-examine the witness who wrote that report. So while you might be able to pull the information from that appraisal report because the information is the same, it's the comparable properties, the actual report and having an expert witness on your behalf doesn't translate the same way. Now, if you closed in November of 2019, don't forget what I discussed earlier. If you signed your contract prior to October 1, you can sometimes pull your comp back into a valid evidence. So it will be important to have all of the facts around your purchase to figure out whether or not even your home, your closing could be considered good evidence.
Anyone else have any questions?
I had a question. If we were to give you, hire you as on a contingency basis, will you be able to decide whether to file it this year or hold it till October 1st in your best opinion?
Yeah, absolutely. I mean, look, the fact is that I would give you my opinion, but it's your decision. you know, if I don't think we would win this year, the truth is I would respectfully decline to take it. And I would certainly, you know, I like to have an open relationship with my clients. I like to be very clear and upfront about it. If I don't think I'm going to win, I will tell you. And if I think that, you know, hey, we can get a small reduction this year and it's better off to wait, then I will absolutely tell you that. You know, reputation is, of course, more important than any particular tax appeal case. So it is important for me, at least, to be honest and tell you what the likelihood is. Now, you're also in a little bit of an unusual spot because you're in Livingston. It's almost certainly going to be worth it to file this year because of the no 15% rule. So even if we can get any reduction, you can be eligible for a reduction this year. But I'm happy to talk to you further offline.
Okay. So Evan, how does someone get in touch with you or follow you?
So I can be reached almost always. Email is great. My website is erdesq.com. All my contact info is there. My office phone number, my email. Again, that's erdesq.com. So you know, please, you can always reach out to me there. You can absolutely send me an email. If an email just includes a property address, I can usually run down all the details and tell you whether or not that's a worthwhile tax appeal. John just put my website into the chat so everyone can see it there.
I see.
Excellent.
I'm just looking. So Nicole's question about a 2 or 3 week close because of a cash payment considered a short sale. No, what a short sale is, and I know I mentioned that as a distressed sale. What a short sale is when a seller is getting less for the home than they owe by way of mortgages or judgments or something else, and that the mortgage banks have taken a cut. If there was some other distressed reason that the seller was selling and the town knows about it, that might be a non-usable transaction also, but it would really depend on the facts of the situation. And it also depends on whether the town knows about the facts of the situation.
Evan, thank you so much for your time, and thank you for everyone joining us for this Lunch and Learn. If you guys have any other topics that want us to discuss, please email us at simon@swkrealestate.com. We'll be happy to talk about any topics that you like. Evan, thank you so much. And again, his website is erdesq.com. And definitely get in touch with Evan if you have any real estate needs for tax appeal or real estate attorney. Thank you so much, everybody. Have a great day.
Thank you very much.
Are you available during this lockout period?
I'm sorry?
Are you available to talk during, is your offices open during the next 2 weeks? There is a lockdown like all the...
I'm certainly available, absolutely.
Yeah, okay.
Thank you, everybody.
Thank you. Bye.
Have a good day.
Thank you.